Hi, my name is Rita Amori Chinda, and welcome to IP Series COVID-19 edition, where we talk about recent IP cases and development as a result of creativity and innovation that get to enjoy legal backing, protection, and a bundle of rights, which could be in form of copyright, trade secrets, trademark, patent, industrial designs, geographical indication, and plant variety. If this is your first time listening to my podcast, please subscribe so you don't miss out on any episode. Don't forget to share and also favorite my podcast on Anchor. And now it's time for IP News Flash. Yay! So, I'm super excited about today's IP News Flash because I have three hot topic for you guys. Number one on the list, Kim Kardashian posted a press release on her Twitter handle on the 8th of September stating that the Keeping Up with the Kardashian show would be discontinued after 20 seasons and 14 years. I mean, that's really huge. Though I'm not a fan, but if you're a fan, tell me how this makes you feel, because I saw comments coming in on social media platform. People were upset and heartbroken that the Keeping Up with the Kardashian show was going to be terminated. But all the same, I think the family have done well so far, and I wish them the absolute best. Now, story number 2. So, Burna Boy recently released his Twice as Tall album, and it was like number one in about 15 or more countries. It was number one, I think, for the last 2 weeks. So, why am I talking about Burna Boy today? So, Burna Boy recently created a merchandise for one of the songs, The Monster You Made, which was, I mean, I've watched the video. I also watched some videos on YouTube where people were commenting or making comments about the video. The video is actually really dope, so you guys can check it out. But my news for today is that he has a merchandise for that song in particular. It has a t-shirt and a face mask. I know because of the pandemic now, everyone needs to wear their face masks. You need to be masked on. And it had a quote which said, "If you're not satisfied with your product, you can reach us at 1-800-NO-VEX." Like, that is dope. Meadow, like, really creative as well. So, merchandising is another way for artists to generate revenue for themselves and also commercialize and exploit their intellectual property. Not just artists, but brands and companies can go into merchandising their works or their creations. So yeah, I think that's something that I would want to see a lot of Nigerian artists delve into. I think DJ Copy did something like that last year, and now we have Burna Boy for his Twice as Tall album, Monster You Made. So yeah, you guys can check out the song and let me know what you think. But I digress again. So, and our last story for today. So I saw a post, I can't remember when, but it said that the Burberry iconic check pattern is a registered trademark of the Burberry Limited. So guys, if you're using the check pattern, which anyone can identify as a Burberry product, please stop doing that, because that's like a trademark infringement. And you know, when it comes to intellectual property, consent, permission, and authorization is key. So yeah, that's it for today's IP News Flash. So yeah, let's get into our episode for today. So on today's episode, I'll be talking about when non-use of a trademark leads to a partial or total cancellation of your mark. I mean, that was really heartbreaking, especially when and you've spent money in registering your trademark. But let's find out what are the grounds for the total or partial cancellation of your trademark. So as we know, one of the fundamentals of a trademark is that the mark in question should be in use and consistently in commerce. So on today's case studies, we have RS Performance AG against Ferrari SPA. So brief summary of this case. RS Performance AG filed a request for the revocation of the European trademark with serial number 6543301. You guys can check it out later. A shape mark and directed to all the classes covered by this particular trademark. Now, these classes will include Class 12 for vehicles, apparatus for locomotion by land, air, or water, airbags, pumps, anti-theft alarms for vehicle, etc. And you also have a trademark registration in Class 25, which covers clothing, footwears, headgears, fitting of metal for footwears, etc. Then you have Class 28 for games and playthings, and gymnastic and sporting articles, edges of skis, etc. And then the remaining mark in Class 28 again for toy vehicles and scale model vehicles. Now, RS Performance did not only request that they revoked their mark, they also were relying on the grounds for revocation. So I'm going to talk about the grounds for revocation of a trademark when we get back. So what are the grounds for revocation of a trademark? Now, RS Performance, while filing his request for revocation of the Ferrari mark, relied on Article 58, Sub 1, Paragraph A of the European Trademark Regulation, which provides that the right of an EU trademark shall be declared to be revoked once an application is made to the office, where stating that for a continuous period of 5 years, the trademark has not been put to genuine use. That is, the person who owns the trademark has not used it from the date of registration and for a continuous period of 5 years. Remember that trademark is territorial in nature, and I wonder why someone will spend money to register a trademark and end up not using it. It's like you doing a CAC registration in Nigeria for a business name or a limited liability company, and you end up not doing anything with it. You just keep it there for fancy. And you know that trademark registration, you register that in connection with the goods or services that you're rendering at the end of the day. Now, and then you do that with no actual reason. You don't have a reason for not using the mark in question. However, if between the expiry of the 5-year period, the trademark owner commences or starts using the mark within a period of 3 months before the filing of the application to revoke the mark, then the application shall be disregarded. However, whereby the commencement or the resumption of the mark commences after the application of the made, then it will also be disregarded. Like the application is going to go through, just like the RS Performance case. Now, why is RS Performance case was heard was because Ferrari had registered their trademarks in the following classes as I listed previously. I'll just say it again. Class 25, 28, and class 12 in the 1960s, and after they made this particular model, the Ferrari 250 GTO, they hadn't made any other model or cars within that same line again since the 1960s, and that is why they've come now to make this application that the Ferrari trademark application in the following classes should be revoked because of non-use. So this is one of the grounds for your trademark being revoked, whereby you don't use it within a 5-year period. That's under the EU law. However, under our own trademark law, section 31 sub 2 paragraph B provides that the grounds for removal of a trademark or a mark from the register can be done up to 1 month before the date of the application if for a continuous period of 5 years or even longer the trademark in question was not in use for the goods or services. So you see that under our Nigerian law, it can even be 5, I think, let's say the minimum is 5 years. There's no maximum. But imagine you registering a mark in 1960s and you haven't used it up to 2020. That's about how many years? That's about 60 years and you haven't used your mark. It isn't fair to your consumers and your fans and the people that actually use your mark or communicate or interact with your mark. However, paragraph 3 of our trademark law also provides that the application may be refused if it shows that before the relevant date or the mark was used by the proprietor for a time being in respect of the goods it was registered. So it's almost like the EU Trademark Act. The difference is that under the EU, you have a 3-month grace period before the filing of the application, while in Nigeria you have a 1-month grace period before the application can be made. Furthermore, under paragraph 4, he also provides that an applicant shall not be entitled to rely for the purposes of subsection 2, which I listed earlier on. We talked about the grounds for the revocation, especially paragraph B, or any other on any non-use of a trademark that is shown to have been due to special circumstances in the trade and not to any intention not to use or abandon the trademark in relation of the goods applied for. So you have to show cause why you really want this person's mark to be revoked at the end of the day. Now, the applicants being RS Performance AG, when I googled them, it turns out they're also an automobile company just like Ferrari. Now, further stated that other than the fact that the trademark wasn't put to genuine use for a continuous period of 5 years, especially coming from a mark that was registered in 1960, and they only used that mark in class 12 for a few years period. This is also similar to the Ferrari 250 GTO model created in 1962 with a relatively small production of the 36 cars. So if you follow the current company trends, you notice that brands like Nike and some other companies like Birkins have incorporated making limited number of goods just to spark interest and make people want to buy their product, make their product more attractive. So yeah, he also stated that now I think during the course of my research I did a Google search and I found out that in 2018 one of the cars out of the 36 that was made, one of the cars, the Ferrari GTO 250, was sold for $48.4 million in California. And this particular model was built from 1953 to 1964 with only 36 models out there in the world. I think if you look at most of the Ferrari cars, especially the GTO, you see that they are numbered. Just do a Google search about that. So yeah, then I come back, we'll talk more about reasons why your mark can be revoked. Yay! So from the little I've said about the grounds for revocation, do you think and the fact that the Ferrari G2O model is still being used, and it's more like a vintage product at the moment, would you consider it to still be in use, especially where the company is not making any of those models again, not even using it in any of the classes, either in class 12 or 25 or 28 that I registered the GTO product. But I know Ferrari has been in the news lately. But yeah, let me know what you guys think. Do you think the representation of a mark should be considered as a requirement for meeting up the continual use criteria? I think to me it's a bit tricky. I think it's a yes and no thing. If the main thing is, can I associate Ferrari to the GTO if I see it today? I think yes. So I would say yes to that question, but continuous use in that class, that's an issue. So yeah, so I think that's where the panel decided to give them a partial cancellation. So they either need to create another model or start producing any of those products they registered under the various classes, so that they can be seen to be in continuous use. Now, moving forward, under our trademark regulation rules, specifically rules 66, it talks about renewal of registration. So when you do your trademark registration, you have to register. So your trademark registration, initial registration, gives you protection for an initial period of 7 years. However, it is subject to renewal, so you have to keep renewing it, even if you do brand expansion or IP expansion into other products and other classes. You have to keep renewing your marks at the end of the day. So according to rule 66, where a trademark owner may leave with the registrar a fee for renewal of the registration of the mark, which should not be done more than 3 months before the expiration of the last registration. So let's say you registered your mark 7 years ago, that should be 2013. 2020 is your year for renewal. So 3 months before your trademark expires, you should do your trademark renewal. I don't know if Ferrari has been renewing their trademark registration for the GTO 250 model in class 12, 25 and 28. But I mean, one would expect that they should, but however, where no fees has been received by the registrar shall notify the proprietor of the mark in writing of their intention to remove the trademark from the register within 1 month. So in Nigeria here, I mean, in practice, and I think things are always different in practice. So normally you're supposed to get, like, if let's say, like I said earlier, you have to renew your trademark 3 months before. So under the law, it provides that a month before your trademark will expire and when you're due to renew, and you're supposed to get a letter from the registrar notifying you that the mark which you registered is due for renewal. And under rule 67, which also talks about the same renewal of your mark, you will be given a 1 month notice before the removal of your trademark from the register. Then a second notice will be given to you to this effect as well. And this is in line with rule 68, and still not more than 1 month before the expiration of your last register. So you're giving graces several times, 1 month before and 1 month, another 1 month again, a second notice again, which has to be 1 month before. So let's just say you have 2 months grace whereby you don't do. So if you've registered your trademark, if you have a trademark and you've never gotten, let's say your trademark is up to 7 years, you've never gotten your notice, please reach out to your trademark agent, ask them to do the needful to help you do your renewal. If you don't want to use the same person, you can reach out to another IP agent, an IP lawyer or IP firm that can help you with your trademark renewal. Else you're going to lose your trademark. So please always remember that your initial trademark protection would last for 7 years, and you have to renew it for another 7 years and another 7 years, which is like 21 years. But you see brands like Amazon, Nike, Microsoft have been there for ages, and they have registered trademarks in various classes, and they keep expanding every day. Now, under rules 70, it talks about the removal of your trademark from the register. Now, it provides that after the above, that's from rule 66 to 68, which talks about 66 talks about the removal, 67 and 68 talks about the notice which you get before the removal, 69 talks about advertisement of non-payment of your money. It has been done. The registrar may remove your mark from the register as of the date of the expiration of the last registration, but this may be restored. However, if you make payment, that is, if you renew, go ahead and make your payment after this has been done. The registration fee, and the registrar is satisfied together with any other condition that he may give you, as he deemed fit to impose. A notice will be issued in line with Rule 72, which is a notice of advertisement of renewal and restoration of your mark in the register. That where a trademark is removed, there will be a record of the removal of the trademark. So you have so many chances. I don't think any intellectual property office or examiner, or let's just say officer, would want you to lose your trademark, because I mean, you registered it because you were seeking legal backing and you wanted to enjoy the exclusive rights that come with all of us. So you need to go all out for it. Don't just register and sit down. So again, as a creative person or an innovator, make sure that you're interacting with the right people, have the right team with you, so they'll guide you properly. Don't say because I got a cheaper offer, I'm going to stick with them. You end up, losing your IPs at the end of the day. So if you need to do your IP registration, always meet an IP agent. So now I'm going further. If under rules 86, if you wish to cancel a mark, just like how RS did, if you need to cancel a mark, just like how RS Performance did, or if you need to do a correction in your trademark, or change something in your trademark, or enter a disclaimer, you must be the registered proprietor, or any person as he may satisfy the registrar may make an application under section 40 sub 1 of the Trademark Act, which gives the conditions for correction of register. You also need to fill the necessary forms, and also provide evidence of statutory declaration. See rules 87. So all of these are there. You just need to interact and talk with you. I don't just, again, I get a lot of comments from people whereby they come to meet me for IP registration. I give you my finger, like, oh, but I got offer from this person, and he says I'm going to get the acknowledgement. I'm like, okay, cool. But then one thing you guys need to know is that your position is the most important stage of your trademark application, because if you skip that stage, you might just lose everything at the end of the day, because you don't know if your mark was approved or is not approved. But I digress. So our focus for today is grounds or reasons why your trademark can be cancelled partially or in total, like you can't even have access to it again. The major reason is not using your mark without a genuine reason as to why you're not using your mark. And in Nigeria, 5 years minimum, there's no maximum. But then again, whereby you start using it a month before the expiration or before the application is filed, you can still retain your trademark, while under the European trademark law provides that has to be done within 3 months. So yeah, that's it for this session. We're wrapping up now. I'm going to talk about the lessons to be learned and the way forward. Okay, so we're wrapping up right now, and this has been a really an interesting episode for me. So what can we learn from the case between RS Performance and Ferrari on the revocation or cancellation of Ferrari's GTO 250 mark in class 12, 25, and 28. Number one, in trademark, when it comes to trademark as an IP, consistent use is key to retaining your mark and owning the exclusive right that comes with it. Building your goodwill, reputation, and also becoming a source identifier. I think Ferrari has done a good job so far, but when it comes to the Ferrari GTO 250 model, I think that's where it's a bit lacking. But in every other thing, I think they're doing a superb job. They already have a good brand, a good reputation, and they also have goodwill as well. But I think it's going to be difficult for them to retain the right to own the marks in the GTO 250 Ferrari model. I think RS is going for that mark, which is why they had to make that application, file the application to revoke the mark in class 12, 25, and 28. But we'll see how everything turns out. Secondly, always consult your IP lawyer. Have an IP lawyer in your retainer. There are various types of law, so you need these various lawyers in your company. You can't use one lawyer or one law firm you can use the law firm for everything, especially a firm that is specialized in the areas which your company deals with. So having an IP lawyer in your retainer is very, 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 very important. Thirdly, just like a CAC registration, where after years of non-use of your business name or limited liability that was registered, it can be struck off the list of registered companies in Nigeria. However, if you intend to start using it, you can pay the penalty for the annual returns, file your annual returns up to date, and then start using your business. It's the same thing when it comes to IP. However, with IP, there's a limited period of time, 5 years minimum in Nigeria, and then whereby you don't have a genuine reason as to why you haven't used it, you stand the risk of losing your trademark. It can be cancelled, and another person could make use of your mark, and you won't have a say. So, as a brand owner, as a creative person or an innovator, especially when you have done your trademark registration in protecting your work, be it your innovation or your creation, please always use that mark consistently. Work with it, make money from it. You own exclusive right to use the mark however you want to. Number 4, always have an IP strategy for brand expansion. This one, number 5, I'm going to say it again. In Nigeria, trademark is for an initial period of 7 years, and this is subject to renewal, which I, listed or stated earlier when I talked about rules 66. And another, so once it's renewed for another 7 years and another 7 years, so far you pay the renewal fee. And finally, think big. Really big when it comes to your intellectual property. Like, you could commercialize and exploit it, you could license it, you could grow a franchise, you can assign it. There's so many options out there. If you listen, paid attention to my newsletter, I talked about Burna Boy Twice as Tall album, where he recently created a merchandise for Monster You Made. Those are the options you have. You can go into partnerships, you can go into collaboration. I also gave an example of one of the GTO 250 Ferrari that was sold in 2018 for about 48.8 million. The opportunities are too numerous to mention. You just need to have the right team with you. When it comes to IP valuation, when they do all of that, just when you know that your creation or your invention is worth more than you can imagine, especially now when the economy is a bit fragile. I know it's going to affect a lot of things, but if you do the needful, position yourself, it's actually going to pan out well for you at the end of the day. So finally, I just want to thank you guys for being patient enough to listen to my podcast, especially this episode. I hope you enjoyed listening to it as much as I enjoyed tweeting about it and recording this podcast and also doing the research. If you have questions, send me an email to ipseriesinfo@gmail.com. You can always send me a DM on Twitter at Esmeraldo99, and just search for Amory on Twitter. You can also check out our Instagram page, Padu Prime Legal Advisory. So yeah, thank you guys for joining. Don't forget to share and favorite on Anchor and other platforms as well. Spotify, Apple Podcasts, Google Podcasts, Overcast, Pocket Cast, Radio Public. I don't think I missed that, but yeah, thank you so much, and on to the next IP series. Bye for now.